So first, panelists. I'm curious, any questions from panel A to panel B? Anything the entrepreneurs have always wondered about how VCs make their decisions? Wow, okay.
They don't want to insult us.
No, exactly. Well, they didn't mind insulting you before. I'm not sure what changed now, Stan.
I'm glad I came a little late.
Well, I'll ask a question.
Okay, great.
So what's your opinion about using outside experts to come in and do diligence before you put money in? Because I've had good and bad experience with those guys.
It depends on, I think, the patent lawyer you hire and how well-versed they are in the industry that you're trying to invest in. And I gave the example of one of our venture partners, Bob Taylor, who is actually, he knows the semiconductor industry really well, for instance. And so we use him frequently when we're trying to investigate those areas. And there are times when our healthcare team will hire somebody from the outside to help them with their projects.
You know, I found that if I know they're expert and I'm calibrated on them, they're very useful. And if I don't know them, they're completely useless. And so a few times I've paid a person I haven't known before, and then I get their feedback and I realize I don't even know how to listen to that thing.
Yeah.
But on patents, I think it's critical, because I think, you know, to be able, a layman like me could not understand a patent landscape. It's too complicated.
So you guys shouldn't feel bad, actually. I mean, my big takeaway from today is there's no right answer, right? It's not so, when we asked how much should you spend on patents, this is an incredibly seasoned panel.
No right answer.
Has anyone got a patent budget? I mean like a 4%
Percentage,
of our...
no, I don't think it works that way. It's very project dependent.
So I didn't have a question, but I had a comment on what panel B said.
Yeah.
Which is the value of a software patent when it's it's an engineering project. That really increases with your execution. Right? Mm-hmm. You have an idea that this thing is very important, but the world doesn't believe that until you've executed and shown that, okay, this is important. And then the patent becomes valuable. Right? It's not just you have this patent in your portfolio and it's important. You really have to go and build it. And that's really the engineering part.
But what Kittu said, I would say if I had to choose between patents and tribal knowledge, I would choose tribal knowledge every time. Because that's what allows you to talk to customers, get things done quickly. And in a lot of fields, by the time the patent issues, you've moved on to something else and it really doesn't matter. So that I really look for that first. And if they can back it up with patents, that's great.
But there are situations, you know, that are mixed. Thinking about Dolby is an interesting example, right? Where, you know, it's a technology. It's valuable as heck because they've executed really well to make it a big deal, and they've built a brand name about it. It turns out that by now the technology is pretty trivial, but it's still Dolby, and they've built a brand on it, and it's, you know, a massively valuable company, and all it does is licenses a patent effectively.
So before I turn it open to the audience, we have talked a decent amount about the patent reform bills that are before Congress right now. I'm not going to put anyone on the spot, but I will note that one of your colleagues from NEA is the chairman of the National Venture Capital Association and sent around a note, which I did share with the class. I did share that with the class, right? Okay, good. I shared that with the class. Does anyone here have a strong perspective on...
I do.
You do?
Very strong perspective. You know, I think that, and this is basically the NVCA's position on this, right? So the bill in Congress is purportedly intended to basically weed out a lot of these patent trolls and things like that, you know, and basically protect companies from and the nuisance of patent trolls. But I think it goes way too far. And as I think you saw in the note, what basically the bill is trying to do is it transfers the burden of paying for legal expenses onto the company if they are on the losing end. And second, they can go after the investors also. And that's something that is, and the interesting thing is who is supporting the bill. And it's Google that's actually supporting the bill in a very aggressive way, right? And they've been very active with the Obama administration on this. And you know, for a company that started off saying, do no evil, it is doing some serious evil nowadays. But we have a very strong position on that because I think it could really hurt startups and it could hurt the venture community.
if it passes as it is, will this change? Actually, I'll do a quick survey.
I
Will it-
have a mixed view of that one.
Okay.
I agree with the piercing the corporate veil. I think that's a ridiculous part of the bill. One reason why America is strong in starting companies is because we have very excellent bankruptcy laws, we have very excellent corporate rules and regulations, and this would devastate the risk profile.
That's the joinder piece in
The
particular.
joinder is just an embarrassment to be in there. But I would prefer, I believe they ought to treat this like any civil suit, and at the end of the trial, because patent cases are very complicated, I think it is part of the judge's job to assign the court costs, and to move the costs onto each side, depending on the burden of proof. It may be that they ought to move 20% from one person to the other, just like in any civil case, you make that decision. It shouldn't be 100%, but I do think it would be a good discipline if they treated it just like any other civil case with the usual civil rules of engagement.
But I guess you don't need a new law for that.
No, but it's in many cases they can't even do that. In most cases, what my experience has been, maybe you guys have different, is you just bear your own cost. And I think that's wrong. So I do think they ought to treat it like any other.
So some of the fee shifting part you like.
Right.
Okay.
But the problem is it assumes that it's trying to solve things at the stage of where it's in court. Most of the stuff doesn't make it to court. Right? Our investors' money is not to support binary outcomes in courtrooms. Right? That's not what they give us money to do. And so the problem is it's trying to find a solution too late in most of these processes.
But I think where startups could be really vulnerable is a large company could threaten a lawsuit on some frivolous patent infringement, go after you, and they have an army of lawyers, they have a very deep war chest, and the only choice for you is to settle, right? And that shouldn't be the case. And so that's one of the reasons why we think that transferring this cost, because for a fledgling startup, even a 20% cost could be huge, right? If they had to go out and fight that. And so you may end up with a suboptimal outcome if this law passes.
One of the things that we wonder about, we universities wonder about, is from the startup's perspective, if the laws pass with fee shifting and joinder, as they are currently described in them, then the startups look like they could end up in a squeeze, in the sense that if there's any chance a university is going to get dragged into a lawsuit that we didn't want to be part of, then the commitment to that startup compared to the commitment to keeping the university running is not even close. And on the venture side, I have to imagine if a law passes where you could make a $100,000 investment in a company and end up on the hook for $10 or $20 million.
Yeah, unlimited liability here.
It would change, I would imagine it would change your investment profile.
Absolutely.
It would have to take less risk.
You would take less risks.
It would, exactly. It would completely change the risk dynamic.
Right. Okay, so we're going to open this up to questions from the audience. Brendan's on that side. Wait for the mic. Question over there from Pat. It is on.
Okay, thank you all. That was very interesting. I have a comment that I hope can be helpful as a former VC. Oren mentioned trying to budget a patent strategy. It's very hard as you're establishing the patents. But in the due diligence process, one of you mentioned trying to get to freedom to operate, which is impossible to do. You don't know what's percolating down at the bottom of the 18-month pile, and you can spend $100,000 in lawyers' fees trying to chase it down and not get anything for your money. So a good strategy in that case is to speak to your lawyer, say, I know the companies that are active in this field because I'm looking at investing in any of them. Please research these 5 companies, spend X amount of dollars, find me what you can, and we'll get as close to freedom to operate as possible. I don't think you can ever get freedom to operate.
Anyone feel like addressing that?
I think that's the right way to do it. I mean, that's where, I think you made a comment about working with people that you know. That's exactly the dialogue you have with a patent lawyer that you know that says, look, we did a company once in heart valves. We need to look at the following 5 companies who play in that space, understand where they're going, and you work with someone who's so sophisticated that they very quickly get to the critical issues.
Yeah, I mean, many people do the freedom. There are 2 levels of freedom to operate. There's one level which is just let's get smarter about it, but not actually get a legal opinion. To get a legal opinion is often 10 times more expensive, but people do that for cover your ass, because it gives you one defense that you weren't intentionally infringing, so you're not subject to triple damages, like Kittu mentioned before. So some people will pay for that, but I don't know what they cost for everybody. I mean, the last one I did, which was a legal opinion, was $210,000. It was incredibly expensive, and it was one of the first bills we wrote starting the company. And that's not what you want to do with a small company, is write a bill to an attorney for a freedom to operate letter, you know.
Other questions from the audience? Question up there.
Excuse my voice, been suffering a cold. I have a question primarily for, I'm going to split it into two parts, one for the entrepreneurs, one for the VCs. For the VCs, is there particularly any space where you find it very hard to invest nowadays? I know early on, you know, a lot of fights were over manufacturing and energy. And nowadays, in order to launch any energy technology, it takes 30, 40 years, well past when the IP is gone. And then for the entrepreneurs, is there a space where it seems where it's oversaturated and it's too hard to really disrupt and break into your own space?
So let me take that VC perspective first. You know, VCs got a funny feature that, unlike in the stock market, you can't be completely contrarian. In the stock market, you can be completely contrarian. Arguably, that's the only way to make real big money. In VC, if you're completely contrarian, that means no follow-on capital is coming to follow in your deal, and then your deal dies, even if it's a good thing. So there are spaces where the venture capital industry as a whole has soured on, and in those places it can be very, very difficult to make an investment. And semiconductors is one right now. Clean tech is one. Capital-efficient products in which capital is not interested in investing in. So can you still invest in those? Can you still start a company? Of course you do, but you have to be better. You have to have the bar has to be very, very high, because you will struggle raising capital. And we as all of us here do some early stage investing, we have to look forward to somebody else is going to come in and follow through.
Wait for the
Thanks. So one of the things that I thought was very interesting, and I believe a point that Greg raised, was that you sounded a bit reluctant to deal with university-backed technologies, because oftentimes professors and the universities are a bit they have goals and aims for their technology that are a bit out of sync with what you might want as an investor. I was wondering if you could kind of compare and contrast dealing with universities versus private technologies, and also if that's been John's experience and how you might negotiate those sorts of arrangements. Thanks.
Sure, I'll give you a couple of examples, but there was some chatter here during the break with similar comments. So one of the problems I have with universities is they'll rarely give you a right to a field from a professor. So you can get their original patent on a drug or on an algorithm, but the university will not guarantee you that the improvement on that will flow to us. So can you imagine the risk you're taking that they're going to license it to a competitor? And so that's very common in universities, that they won't give you future rights to a field. Whereas when I work with an SRI or a corporation, I can get margin rights, or at least right of first refusal or something on those rights. And so that's one of the issues. And then there are other issues having to do with defending the patents and other filing issues, which are really annoying. But the bigger problem sometimes has to do with the professor, I hate to say, because it is their child. And often they want their child to grow up to become a pianist, and we want them to become a plumber. And that leads to a conflict. And again, in the industrial environment, they're usually really just interested about the money or just getting their idea out. So we've had those kinds of problems. But the universities vary incredibly widely in terms of how astute they are about this.
We've actually had very good experience with investing in companies that have been spun out of universities. We've invested in companies out of Stanford, out of Berkeley, out of University of Washington in Seattle. So our experience is very good. I'd say about the only thing that I would add to his comment about sometimes the goals of the company and the goals of the faculty might diverge a bit, and you just need to figure out a way of converging those as quickly as possible and getting on the same page. But otherwise, we've had there've been some terrific companies come out of there.
Yeah, we have as well, and I've invested in a lot of university companies, and the general difference I would say is that companies and universities tend to be more innovative, but they tend to be rawer. And generally, they are farther away from product than the start founding group thinks. So it's often our job to kind of tell them, hold on a little, let's make sure we finish everything before we step on the gas and start spending a lot of money. But provided you have the patience, some great things come out of it. You just need a little patience.
Yeah, I mean, we've invested in a few university startups, and I think there's nothing inherently challenging or structurally wrong with how universities are licensing technologies to startups. I think that in a lot of cases, some frustrations may arise where maybe a university hasn't had that much experience in licensing technologies directly to startups and aren't completely up to terms with it. I would say that over the last few years, that tide has been changing, and offices are becoming much savvier. And I think launching a university startup today is much easier than it was 10 years ago. And there's a lot of pros and cons to licensing a technology for a startup from a university. One of the cons is it may take a little longer for the licensing process if that particular university isn't that experienced in the licensing process for a startup. And there are obviously field of issues that Greg mentioned, but there are a lot of pros to it as well. There's been a lot of dollars poured into that research. It's pretty easy to tell how advanced and innovative that research is, and rarely in technology you get opportunities where you can invest in something that's been incubated for so long and tested for so long in a very innovative space as well.
Can I give one more negative though?
Just oh no, that's all the time we have.
Yeah.
No, go ahead.
No, it's just something to look out for. This is one case where we actually ended up suing and countersuing the professor. And the reason was, as a very innovative person, they had grants from the U.S. government, they had grants from industry, they had the university's own support and stuff they claimed they were doing on their own nickel in the car, driving between the university, the government. And so 3 of those entities all thought they owned the same IP. So, and the university, this particular university, was a little clueless about the fact that they got themselves into this problem, because it should never have happened, but it did happen. And so that's the kind of thing that
Sorry, go first.
So no, I wanted to say it depends on the individual, it depends on the university. Right? Some people know what they're doing. They're more savvy about it. Some people are clueless. So you can't put a blanket statement that faculty are bad, universities are bad.
That's true.
And in fact, one thing that I've often said, in audiences invited by Oren, that nothing trains you better to being an entrepreneur than being a tenure track faculty. The process is actually exactly the same. What do you do in a university? You come here with an idea. You based on an idea, then you write grant proposals to get funding, right? Then you build your team. You build your product. Then you go out and give talks. You sell the product. Finally, the tenure letters comes. In all this process, nobody's telling you you should do this, you should do that, right? Any other job that you go and get, you're working at Goldman or wherever, there's somebody telling you do this, do that. Here, you're out on your own. You're building your company. Getting tenure is like building a company. So you find the right faculty. You can't have a better trained entrepreneur than right.
Yeah, it's just to touch on from the university perspective. There were a few things that were mentioned. One thing is we talk to our faculty a lot when they're starting companies to say, unlike your lab, statistically speaking, actually it's a great quote from my colleague from MIT, you may think you're getting married, but many marriages end in divorce. And statistically speaking, it is unlikely that the faculty founder will still be the CEO of that company 4 or 5 years down the road. And that's a perfectly natural process. But it's a foreign one to many faculty members who are used to controlling their own destiny.
I think that is the biggest issue that I've had, which is, and it's not just with faculty members. I usually have this conversation when I'm investing in a company. Right up front, I ask the entrepreneur, do you want to be rich? Do you want to be regal? Right? Because everyone wants to be rich, but some of them secretly harbor a desire of being regal. And they want to be in control, they want to be the CEO of the company. And sometimes their skill set doesn't lend itself. And so if, in my assessment, it's not a match, I have that conversation up front because we can be friends. You don't need to take my money, I don't need to invest in your company. But if you are going to do that, then it shouldn't be a bait and switch.
So the second point I was going to make, which came up earlier, is universities are all trying to figure this out ourselves too, in terms of what are the ground rules around startups. We've gone from doing 4 or 5 technology-based startups a year when I first got here. Last year we did 18. This year we're on track to do more than 20. And that's just from the tech transfer office. So that's not counting all the ones that have no university IP or have no university IP, depending on the situation. But one of the things we do talk about is the reason why university conflict of interest committees exist in many ways is to actually help flesh out the very problems that Greg described of it's not always clear where ideas come from. And the last thing you want to do is come up with a muddied pool behind something and only find that out after you've invested $20 million in bringing the product to market. So while it seems like a pain and people complain vociferously about having to spend an extra month or 2 fleshing this out early, far better to spend a month or 2 fleshing it out early than end up in court 10 years later, or in prison, which has also actually happened to a few faculty members, unfortunately. Not here, by the way. No one at Columbia ever did that. But what I will say is the universities really have changed a lot. So I was on a panel at Autumn, our industry association, this year. It was us, UCLA, Caltech, Carnegie Mellon, and Pittsburgh. And we were talking about all the changes that we've all seen and all the different ways that universities are trying to learn from each other about how to make this process more transparent, faster, and have the deals be more appropriately scoped for a startup. And we're learning too, right? So we're learning from you guys, we're learning from our past mistakes. And we have to, so. Yeah, exactly.
Past mistakes?
No. Past educational opportunities. Great.
What is true is that now is an unusually good time, or relative to other things, to do a university startup, simply because there's so much money in the system. There's a premium on differentiation. University startups tend to be much more differentiated than any sort of standard thing started by a bunch of engineers. And it's easy to raise a lot of money, and sometimes it'll take you quite a while to finish the university technology. So you stand out more, and you can get the money to give yourself the time to go finish it. It hasn't been this good in a long time.
Great. I did promise I would let the panelists get out of here to get to meetings that happen at noon. So unless any of the panelists, any final comments people want to make? We're good. Please join me in thanking the panelists for making their time today.